Welcome back to my corner of the internet, guys. I am the Lucid Dream, and today we've got a video of a sovereign citizen who thinks that just because the judge told him that he was competent to represent himself, that means he is competent in the law. We are going to find out that that is not so. First and foremost, thank you to all of my channel members and subscribers. Without you, I would not be here. So as always, every day, thank you. Let's go ahead and get into it.
And these signs are something else, aren't they? Now, I filmed in this courtroom before, and they tried to stop me, but I threatened them with citizen's arrest. This sign over here says persons and parcels entering courtroom are subject to search. That's not true. It's a Fourth Amendment violation. No search or seizure without a warrant signed by a judge based on an injured complainant's sworn statement of damages, which just cannot occur for this. And then this one over there is saying pursuant to UTCR 3.180 and SLR 3.181. And I don't know what either of those are. They're not ORS, Oregon Revised Statute. They are some sort of court rule or something, which is not a law and doesn't apply to me. Just narrating for my video.
What videos you make?
What's that?
What videos you make? Just like exposing corruption? Or?
Yeah, citizen's arrest.
Oh yeah, dude. So, look at these cops, you know what I mean?
They're criminals, man.
Yeah.
This here is the 6-page.
They're the most dangerous gang in America.
Yeah, for sure. This here is a 6-page criminal, federal criminal.
Against you?
No, against whoever's taking part in this against me.
Okay.
For extortion, deprivation of rights under color of law, conspiracy against rights, treason, domestic terrorism, and conspiracy to attempt murder.
What the fuck?
Dude, they fucked me up in the jail. They did not do me a service. They like froze me and they like stuck me on the concrete for like 6-7 hours. I'm all screwed up. I have motor neuron disease, so they dang near killed me. I'm not kidding you. Yeah.
Not right now? No.
Eventually they came in and found me just basically catatonic, shaking, and just...
Having like a seizure type?
I don't know. I always shake, and the more I use my muscles, I get to a point where I'm just like completely out of control.
Your nerves?
Yeah. And they put you in those concrete cells, and there's no padding, there's no place to sit.
Yeah.
You're right on the conductive surface, so you're freezing.
They just leave you there for fucking hours, and they take their sweet ass time. Yeah.
7-8 hours later, it's like, dude, are you kidding me?
Here's an idea. Stop breaking the law, and then you won't have to deal with it. Problem solved.
All right. Please be seated. Okay, next let's take up State of Oregon versus Kennedy Walker, case number 24CR0709. Are you recording right now, Mr. Walker?
Oh, I don't answer questions. Pursuant to the Fifth Amendment.
How am I supposed to? You don't have to answer. I'm not asking you questions regarding the crime. I'm asking you the Fifth Amendment of the United States Constitution offers you the right to remain silent against any kind of criminal prosecution or any kind of investigation.
Are you providing me legal advice?
No, there's a comment that you have to ask.
Okay.
So, are you recording right now?
Oh, I don't answer questions pursuant to the Fifth. I will go ahead and invoke my Fourth Amendment right to be secure in my property and my First Amendment right to freedom of press, though.
No, we're going to get through this one right now if you don't want to. Are you waiving counsel?
I am.
Okay. Did you fill out the waiver of counsel form?
You should have it, don't you? Do you not have it?
Okay. You're answering my questions right now.
I'm in charge of what I answer. I hold my own counsel, so I'll decide.
Okay. So here's what we're going to do. You have an electronic device that's beeping on your chest. You're not allowed under rules to record during the court proceedings. I don't know if you're recording or not. You won't answer my question. We are going to reset this till tomorrow, so you need to come back tomorrow at 1 o'clock. And you shall have no devices on you or any kind that could potentially be recorded.
Okay.
And you do not hold your account.
At this time, I'm going to go ahead and place you under a private person's arrest under ORS 133.225. I'm including in this federal criminal complaint extortion, deprivation of rights under color of law, conspiracy against rights, treason, domestic terrorism, and conspiracy to attempt murder under RICO. At this time, deprive me of my First Amendment right to counsel.
Not at all. You're welcome to apply for an attorney or hire an attorney.
Well,
You told me you didn't want one.
I'm already placing you under arrest for treason. Treason is actually, because treason is something that enemy combatants do during wartime, you actually don't get a trial. So from this point forward, you will no longer hold the bench anywhere because traitors are not allowed in public service. At this time, I'm placing you under arrest. I would like to get a bailiff to transfer custody of Judge Hung, and then I would also like him to contact a federal agent to transfer custody.
So this guy really is next level delusional. This is not the first time he's tried this. There are other videos on his channel where he's quote unquote tried to arrest people. And obviously it doesn't work because he's a moron. But he continues to try it. That takes some very, very strong dedication to this particular brand of stupid.
Mr. Walker, you can tell me you're under arrest already. I'm giving you two options.
Pursuant to ORS 133.225, a private person may arrest another person for any crime committed in the presence of the private person, if the private person has probable cause to believe the arrested person committed the crime. I do have that. A private person making such an arrest shall, without unnecessary delay, take the arrested person before a magistrate or deliver the arrested person to a peace officer. Is there a magistrate here to deal with this?
Right in front of you. That's me.
No. You will never sit the bench again because you've been accused of treason, and you don't get a trial because we're at war.
I'm going to give you two options right now. Option number one is you come back tomorrow without any kind of potential recording device, and we can complete this process. Option number two is I can find you in contempt for inability to complete this process.
You're not a judge, and in fact, you're in my custody.
So which option would you like to go with?
At this time, I'm going to invoke my Fifth Amendment right to remain silent.
Let me ask you this. If I let you leave now, will you come back tomorrow 1 o'clock without me?
Why can't we do it now? It's pretty obvious that I'm competent counsel for myself.
Because of the device that you won't ask. If it's not a recording device, that's fine. But you're not allowed to record during the process. So again, and if you don't want to answer the question about the recording device, fine. But I'm worried not to have any device on you tomorrow. So do you want to do this tomorrow, or do you want to?
You're no longer a judge. You've been arrested for treason. You don't get a trial. You are guilty under wartime rules already.
I need you to understand that I'm unable to complete these proceedings right now because you don't answer my questions. Or I'm giving you an opportunity to come back tomorrow. Which would you like to do?
At this time, I'm placing you under arrest under Oregon ORS 133.225. The charges include extortion, deprivation of rights under color of law, conspiracy against rights, treason, domestic terrorism, and conspiracy to attempt murder under RICO.
I'm going to give you one more chance, Mr. Walker.
I'm ordering you to take this man into custody. I'm going to transfer custody. Are you the sergeant? Are you the ranking officer here?
Yes.
I am going to transfer custody to you. I need you to contact a federal agent, and this is the federal criminal complaint outlining all of his charges.
I'm going to try to work with you as much as possible, Mr. Walker. I'm going to give you another chance to come back tomorrow.
I'm ready to proceed with the hearing today, and I'm here today, and I'm handicapped, so I'm not going to be going through a whole bunch of unnecessary and extra steps, because that's not equal protection under the law, which is my 14th Amendment requirement. I am guaranteed equal protection under the law. That means that I don't have 10 hearings. I have the same amount of hearings as what's standard. I'm here ready to talk about whatever you want. You're the one refusing. And honestly, I'm going to tack on a disrupting my business estate charge if you do that.
Given that you're willing to talk about anything I want, is that a recording device?
I don't answer questions pursuant to my Fifth Amendment right.
Talking about anything I want? Well, I'm trying to do this, Mr. Walker. I'm holding you in contempt 30 days custody.
Your Honor, who's the complainant?
There is no complaint.
Exactly. I have a Fourth Amendment right not to be seized without a warrant. I need a federal agent here to deal with this federal complaint. There is no complainant. Lawyers, you guys know there's no complainant. That means I cannot be seized without a warrant. You cannot get a warrant unless you have an injured complainant that is going to sign a statement of damages. You don't have that for the original case, so this original case is not legitimate in any way. There's no complainant, and I actually moved to suppress the warrant because it's illegal on those grounds, and I also moved to dismiss the case because there's no warrant, there's no complainant. And I have a right to face my accuser. That'll be a Sixth Amendment right. And there is no accuser. There is no crime. I've never been accused of a crime. You don't, your charging document doesn't even have a complainant listed or anything.
That's not my charge. I'm willing to. Okay, I'll give you one more chance. You want to try this again tomorrow without a recording device, or am I going to continue to hold you in contempt?
Under duress, I will go ahead. I mean, hold on a second. You're saying I'm going to jail no matter what?
No. I'll give you a chance to come back tomorrow if you come back without any devices and cooperate with me tomorrow.
And I will agree to that under duress.
Okay, so come back tomorrow. I'm not going to hold you in contempt. No devices, nothing that beeps or shines or they could possibly record. And then we're going to go over.
What about my? Do I have a Fourth Amendment right to be secure in my property? Can't I have whatever property I?
You cannot take whatever property you want wherever you want. Fourth Amendment right is to protect you from taking your property.
But isn't this a public trial?
You can't bring a gun in here. That's your property.
Well, this is public property, and I have a Second Amendment, so actually.
Do you want to come back tomorrow and cooperate with me, or do you want to go to jail? Let me know the appearance of it.
Well, if you're asking me what I want, I'd rather proceed right now. But I certainly don't want to go to jail, so I will come back tomorrow if that's the only option available.
Well, that's not the only option. You know the other one, but I think it's a better option.
Right.
So he agrees to come back the next day and behave himself. And then this guy comes back the next day and records the hearing secretly. But not only does he record the hearing secretly, he puts it on YouTube, where inevitably the judge is going to find it, because this was only a day ago. The judge is going to find out he disobeyed a court order. He's going to be held in contempt. And the charges he's facing, these aren't traffic charges. These are felony drug charges. So this guy is essentially massively fucking up his life right now.
Do you understand that?
Yes.
Okay. Do you understand that you're currently being charged with attempted unlawful delivery of Schedule 1 controlled substance, which is a Class B felony, maximum penalty is 10 years in prison, and a fine of $250,000, and then count what's listed on the indictment is count 3, but it's actually count 2, unlawful possession of Schedule 1 controlled substance, which is a Class B misdemeanor, maximum penalty is 3 years, count 40, and you have a fine of $6,200. Do you understand that?
Actually, I think the first citation is wrong because I believe that citation, when you look it up, is actually a Class A misdemeanor.
I'm just telling you what the state has charged. What I don't know is right or wrong.
Well,
Just telling you, I just want you to know that's what you're charged.
besides the discrepancy, I suppose I don't know. I mean, shouldn't it be corrected before I understand it?
I am not asking if you understand the severity of the charge. I'm asking you to just simply understand what they charged you with.
Well, right, but I'm saying that if the citation is not a Class B misdemeanor, then, which it's not, when you look it up, that citation is a Class A felony. Excuse me.
They charge you with attempted unlawful delivery of Schedule 1 controlled substance, or with attempted crime. It drops it from one level. So from an A felony to a B felony, you attempted A misdemeanor to a B misdemeanor. So do you understand those are the charges against you?
I believe that the level of the charge has to do with the narcotics schedule.
Yeah, I didn't charge you. The state charged. I'm just telling you, you understand that's what they charged you. Whether it's right or wrong, you understand what that's what they charged you.
I've read the paper and I know what it says.
Okay. And then if you understand, you can change your mind anytime, and if you want to train later on, you can always hire one or apply for one later on.
Yes.
Okay. Knowing all that, everything in this waiver form, everything I've gone over, do you still wish to proceed with down the training?
Yes.
Okay. Accept your waiver, finds knowingly, voluntarily, and intelligently made. I can do one of two things today. Number one is if you want your day at trial, then I can go ahead and have you back to please do and set this to trial. The option number two is if you want more time before you enter a plea, I can set a plea date at a later time and have you come back before I enter a plea. Which would you prefer?
I'll plead not guilty now.
Okay. You're not guilty plea for the record. Set this to trial. The parties available for trial on September 16th and 17th.
You're asking me?
Basketball team.
I would say yes.
What did you say? September 16th and 17th.
No.
Great. We're done there. Thank you.
Okay, thank you. Your Honor, I'd like to take this opportunity to go ahead and place the prosecution under arrest for treason. I'm going to go ahead and transfer custody to you. And then I would like you to win.
He almost managed to be a normal human being or a semi-normal human being up until the point he attempts to arrest the prosecutor for treason. If you didn't know, this guy has a book on Amazon about treason. How much you want to bet he knows absolutely nothing about treason? Thank you so much for watching, guys. I'm going to keep an eye on him. I feel like there's probably more entertainment in the future, at least until the point he goes to prison for whatever drug charges he ends up getting convicted of. Please consider leaving me a comment to share the video. I would appreciate it, and I will catch you on the next one.